Welcome to panel number 8, I think. My name is Monika Anna Król. I am from Poland. I'm associated professor of environmental and agricultural and administrative procedure law. I work in department of comparatistic and interdisciplinary research in Faculty of Law, University of Łódź. As you see, our panel is women's power for girls. Let me introduce, this is Dr. Zuzana. Yes, Dr. Zuzana from Comenius University from Slovakia, Dr. Barbora, Dr. Barbora from Brno, from Czech Republic, and Dr. Anna Maria from Károly Gáspár University from Hungary. So it is, I think, the first panel which is in such girls' power section. I decided to make it a little different way than in the previous panels, because I ask my girls 6 questions. So I will show a few slides, and after that I will ask the questions and ask them to answer. I do hope it will be a little bit more dynamic, because this is the second day, this is 8th panel, so we are a little bit tired, and we need something to involve our mind. So our section was legal framework for administrative offenses in environment protection matters, defining responsibilities, compliance, and sanctions. So the first thing was the concept of administrative norm. And each norm consists of hypothesis, disposition, and sanctions. In hypothesis, we are asking who is responsible for administrative protection or environmental protection. Who is responsible? Natural person, legal person, business companies. Disposition. It means who they have to do or avoid doing something. And finally, sanction. What kind of sanction it is a question. So the first question arises: how sanctions for violations of administrative regulation are enforced? Are they enforced in administrative procedure? And what is the nature of those sanctions? If they are still administrative sanctions, or they started to be penal sanctions, penal character sanctions. And are sanctions laid down in different procedure? What kind of procedure is it? Is it still typical administrative procedure based on code, on procedure, or it is something special? There's something special procedure created in the regulation of the country. Is it a penal administrative procedure? Is it maybe misdemeanor procedure? What kind of procedure is it? And the second question is there a codification of administrative law? It's a code. The procedure is codified. And if so, if there is a process of gradual further codification, like in Poland, and we are incorporating new areas to the code, or is a disintegration of the code system. So we have 2 first questions, So, first of all, I will make a short presentation to everybody, what we are talking about. In Poland, we have a very traditional system This is the code from 1960, which is really based on Austrian first procedure from 1925, which is 100 years old this year. Yeah? So we made the first regulation in 1928, just 3 years after Austria. But the code made in 1960, it was the developing version of the first one. Very traditional administrative, let me say, Austrian procedure. Yeah? In 1971, we made the Code of Misdemeanors. It was the second code. The first was in 1928. In 2001, we made a Code of Procedure in misdemeanor cases. So it shows you that we have two different procedures. Yeah? We have administrative law, administrative procedure, and we have a misdemeanor case law and misdemeanor cases procedure. Very, very traditional. In 2002, we created a law on proceedings before administrative courts. It's a law, it's on the code. And we changed the Austrian system because we had till then a kind of Austrian system. We had only one level of court control. Yeah, at this moment from 2004, we have two steps, two levels of court control. Hungary, who is the expert of Hungary. Yeah? In Hungary, in 2016, is a general public administrative procedure. In 2012, administrative offenses, a kind of misdemeanor, if I understand, administrative offensive proceeding and the administrative offense registered system. And 2017, sanctions for administrative entanglements, yeah? Offenses, probable offenses. I start with Slovakia. Slovakia Administrative Procedure Code 1976. The Act on Infraction 1990. And Administrative Judicial Procedure Code 2015. Is correct? I do hope. And Czechia. Czechia made a revolution. It's a huge reform. It's a huge reform because they have Administrative Procedure Code from 2004. They have 2016 Act on Liability for Offences and Proceeding Concerning Them. Special Offences Court Act and Code of Administrative Justice. And Matus is my witness because when I got the report, every report was really great. Thank you, girls. I thought I got the wrong report. Yeah, it was right. I got the wrong report. It was something. It is criminal. He said, no. This is bad reform. I said, okay. Yeah. So the system, it's really different. But we have an expert who will tell us a little bit about that. So, first of all, but two questions. Girls. Yes, please.
First of all, I want to thank you for invitation and to have an opportunity to be here in such interesting conference. And thank you also, Monica, for your questions. So the first questions related to enforce in administrative procedure and to force sanctions. And given the fact that the norm is administrative, its enforcement is regulated by administrative procedure. If the administrative norm is an infraction, that is a minor offense committed by natural persons, then Act on Infractions applies with a subsidiary use of Act on Administrative Procedure. Act on Infractions is here a specific procedure focused on punitive procedure. On the other hand, if a legal person is responsible, then Act on Administrative Procedure is used, just it. This act, however, is very general nature. and doesn't not reflect specific needs that arise from the punitive nature of this procedure. Sanctions themselves, they are always laid down by a specific legal act. They are not stipulated within general act such as Act on Administrative Procedure is. In Act on Infractions, we distinguish fines, and they apply to all infractions. Then the admonitions, forfeiture of property, and prohibition of activity. They are stipulated in this act given the fact that it is not only a procedure act, but also have a material scope. However, in legal practice, almost only fines are used. So this is the first questions, and the second questions concerning with the codification of administrative law or code. So yes, administrative proceedings in Slovak Republic are primarily governed by the Administrative Procedure Code, which served as the general procedural statute for public administration. The public administration bodies, of course, use also another legal regulation in their procedural activities, but most commonly applying the Administrative Procedural Code subsidiary. One such regulation is, for example, Act on Infractions. But the Act on Administrative Procedure, also in Slovak Republic, is really old. It's from 1967. So some of its provision are old, obsolete, and would need just adjustment and clarification. But despite of this fact, its use in public administration by public administrative bodies is customary. Some new institute, like for example electronization in public administration, were resolved by reference to a special legal regulation, to new regulation, and in Slovak Republic it is, for example, the E-Government Act. But I have no information that Slovak legislator is preparing any significant change to the Administrative Procedure Code or even the adoption of something completely new regulation in the near future. So now we have just this old Administrative Procedural Code. Thank you.
Good afternoon, ladies and gentlemen. First, I would like to thank you for having me. It's really an honor, and I was very looking forward to getting to know how the protection of the environment works in all the 4 countries. And thank you very much for the questions. I feel kind of special that our panel has 5 questions, and I'm very curious how the dong's gonna work when we're gonna be back and forth. But anyway, to the first question. So the enforcement of obligations imposed in administrative proceedings referred to as a administrative execution or a compulsory enforcement. And it's an indispensable component that represents the final stage of the administrative procedure. A prerequisite for enforcement is the existence of an enforceable administrative decision. And then the enforcement procedure differs based on the nature of the obligation. So if it's a monetary obligation, typically fine, or non-monetary obligations. In case of fine, monetary obligation, the administrative enforcement is not regulated by the Administrative Procedure Code or Act on Liability for Offences. Instead, the procedure for tax administration applies, which is primarily governed by the tax code. So the enforcement authority for monetary payments is the General Tax Administrator. In case of non-monetary obligations, the administrative enforcement is governed by the provisions of the Administrative Procedure Code, and the enforcement authority in this case is the administrative authority that issued the decision on the offense. Then the sub-questions, or the sub-question is if the sanctions are laid down in a different procedure. Well, no. The sanctions are laid down in proceedings concerning offenses. The process is law-regulated procedure aimed to determine if an offense has been committed, identifying the perpetrator, assessing the legal classification, and imposing and enforcing an appropriate administrative penalty. the primary legal resource of this procedure is Act on Liability for Offences. And then to the second question is if there is a codification of administrative law. Well, for me, it's kind of a very complex question because administrative procedural law, particularly in area of the administrative liability and environmental law, is not regulated by a comprehensive piece of legislation and therefore remains uncodified. And when applying administrative procedural rules, authorities primarily rely on special provisions contained in specific environmental statutes. The generally provisions of the Administrative Procedure Code apply on subsidiarily only where a special law or special statute does not contain its own procedural rules. In environmental law, such special statutes include, for example, Act on the Protection of Nature and the Landscape, the Water Act, or the Waste Act. While the General Administrative Procedure Code established the overreaching procedural framework for administrative proceedings, in matter of administrative liability, the key legal instrument is the Act on Liability for Offences. Nevertheless, even this act only applies subsidiarily as long as special environmental laws contain their own procedural or substantive rules, which then take precedence over the general provisions. This special environmental protection statutes laws typically contain their own definition of administrative offences, specify the competent administrative authorities responsible for hearing such cases, and may also provide for particular procedural rules governing the conduct of proceeding. And this fragmented legal framework poses practical problems, especially with respect to the jurisdiction of administrative authorities, which under various environmental protection laws are responsible for hearing cases of administrative offences and imposing penalties. So in the field of environmental law, a single act may be or may meet the elements of multiple administrative offences defined in several sectoral environmental protection acts, and as a result, both substantive and procedural provisions governing the administrative liability are often fragmented among these individual statutes. So consequently, the joint proceeding that are expected from the Act on Liability for Offences is frequently not conducted in practice, so it may lead to situations where the same offender for the same act, for the same conduct, is in several or parallel administrative proceedings is being punished for the same act maybe like twice, maybe triple times, thereby potentially violating the nebis in idem principle, which is the prohibition against double punishment for the same act. Thank you.
First of all, let me thank you this opportunity for the research and for the appearance in this conference, and especially thank you for Professor Król for these questions, because in my point of view, these questions put the focus on the structure of the regulation in this field, mainly the administrative proceedings. So let me tell you the answer for the first two questions, which are so close to each other. So maybe I would start with the second one, the second question, because it can be the basis of the first one. In Hungary, we can say that we have two codes. In the field of environmental protection. The first one, as you can show us, is the Code for General Public Administration Procedure. And the second one, which is also the part of the constitutional and administrative regulation, is the General Rules of Environmental Protection. We can say that the government or the parliament can add some other specialized regulation to the AKR, to the General Procedural Code. It means that these special regulations can contain other administrative procedural regulations other than the AKR. The ACAR itself, so the General Procedural Act itself establish what is the connection between the General Code, the General Procedure Code, and the other specialized procedure regulations. It can be also, for example, a governmental decree. According to the AKR, this connection can be three types. Here, I have to emphasize two, and especially one type, because the first one is the case which is close to Barbara's speech, but cannot applicable in the field of environmental protection when the AKR cannot be applicable. The proceedings where the AKR cannot be applicable, but in the field of environmental protection, we can use the General Procedure Code, but the AKR itself may derogate procedures, regulations from itself. And when it can be declared in the AKR, we can use the specialized procedural act or governmental decree. It's free. The first question, we can say it was also a very good question. Thank you again. We can say that in the Hungarian administrative procedural law, the sanction, we mean it fine. Mostly in the environmental protection, is imposed in an administrative procedure. The misdemeanor procedure is truly and deeply separated from the administrative procedure in the Hungarian system. The enforcement, if it's sufficient, I have to add, is also the part of the administrative procedure. This is the third part according to the code, according to the AKR. It is the 11th chapter of the AKR. So we can conclude that the administrative sanction is imposed and enforced in the same administrative procedure. There is no possibility to mix the mentioned procedures, I mean criminal or misdemeanor procedure. So these criminal and misdemeanor procedures are not connected to the basic administrative procedure. I mean the basic is the first part of the administrative procedure. So based on the analysis of the field of environmental administration, it can be established that the legal consequences affecting the client arises in two areas, namely in administrative proceedings and in misdemeanor proceedings. In Hungary, it's strange connection between administrative procedures and misdemeanor procedure. It's also a war between the administrative lawyers and criminal lawyers because the misdemeanor procedure and misdemeanor regulations are a little bit has a two-faced in Hungary. One face is the criminal one, and the other face as the administrative bodies are mostly the base of these procedures. So it's also a little bit a strange question in Hungary, but a conclusion that there can be no overlap between the two areas because while the sanctions imposed as a result of administrative proceedings are the consequence of acts against the administration, administrative offense proceedings and sanctions are the consequence of acts that are less dangerous to society compared to criminal offenses. Thank you.
The term offense or offenses, written in different way. I checked in British English, it refers to violation of law and unlawful act of wrongdoing. This is offense, yeah? So this offense is a kind of violation of administrative law, administrative offense, or administrative delict. And my question is, it has been legally defined. Of course, we are using English term, but we have, of course, Polish, Czechian, Slovakian, and Hungarian terms, which are completely different. So we have to transfer it into English and try to answer the question. Polish is very typical, traditional legislation. We have crimes, so we have criminal law and criminal proceeding. We have misdemeanor in this traditional concept. Misdemeanor law and the misdemeanor proceeding. And finally, we have kind of administrative delicts, which is administrative law, material law, and proceeding. This is but finally we have a kind of penal sanctions. And in 2017, we have added to our code, because our code is, modernized all the time. So we are trying to put everything in the code, even if it's 65 years old. So it should be retired this year. But it is not, and nobody is thinking about it. It's very traditional. So we have a kind of administrative fines, and we have added the chapter to the code. Yeah? But we have no legal definition of administrative delicts. If you want to find, you have go through the doctrine, especially Wojtek Radecki, professor, who should be with us, and he should be the moderator, because he knows Slovakian, Czechian legislation like Matus or our colleagues. Yeah. Hungary has a misdemeanor concept. You have told us about it very clearly. So it's connected. It's more similar. Maybe either an act on omission, it's dangerous to society and punishable. And no misdemeanor can be established in the act of omission constitutes a criminal offenses, or if the act of omission is punishable by a fine imposed in administrative procedure under law or municipal regulation. Yeah. Czechia, this fantastic new act, paragraph 5, the act of liability offense is a social, harmful, illegal act that is especially signified by law and exhibits specified characteristics, but it is not a criminal offenses, so it's divided into two groups. Exceptions are disciplinary offenses and public order offenses. And this great reform, combining responsibility for existing offenses, prestupki, and other existing administrative offenses, inne sprawni delikty, delikty, into a single legal act under the common name of responsibility for offenses. Odpowiedzialność za przestępki. Slovakia. Administrative offenses, crucial concept in Slovakian administrative penal law. So they have created a kind of penal administrative law. Encompasses by types of administrative violation found in the legal system, unlawful conduct in the elements of which are established by law and for which the public authority imposes a sanction prescribed by administrative law, an offense and infraction. So my colleague used the name of the act, infraction. So the other name, yeah? No offenses, but infraction is a culpable. Remind, please. Culpable act that violates or endangers social interest and explicitly designed as such in the act of infraction or other statutes, yeah, provided it does not constitute other administrative offensive punishable under the special legislation or a criminal offenses. So, my thought was, Is it based on guilty? Yeah. Fault, guilty, based, responsibility, or not? So, are proceedings in cases of administrative offenses based on the concept of guilt, fault, or it is not related to the obligation to prove fault? Poland. We have very traditional concept, but it is without the obligation to prove fault. Without obligation. I talked to my friend, our judge, Diana Czcińska, and said, who should prove the fault? In administrative procedure, in our thousands of different bodies, Professor Tomasz Bojar told you, so many we have, yeah? So this is the responsibly, without the obligation to prove fault. And it is addressed not only to natural person. Hungary defines 3 forms of liability: criminal, civil, and administrative. Negative impact on the environment, which also constitutes the conduct given rise to liability, may take the form of endangered or damage. Liability for environment damage or environmental hazard lies with the owner or possessor, user, of the property at the time of the environment damage or environmental hazard occurred. So, this is presumption of liability without obligation to prove the fault? For me. So, it's the question to you. Czechia, maintaining the differentiation between the ground for liability between 2 categories of entities. Ordinary person, natural person who are liable if their guilt is proven. Yeah? You see the difference. Legal person of natural persons who are entrepreneurs, who are liable on objective grounds regardless of guilt, but with the possibility of exemption. Completely different concept. Slovakia, an infraction of culpable act. You use in every culpable, unlawful act. So you should prove the fault, the guilt. But my question is, it has the form like in criminal law. So is this unilateral guilt or international guilt? So you have to prove in these 2 concepts. Okay, so floor is yours.
Thank you for your wonderful presentation. Really, it's really interesting. So the third question was that if the concept of violation of administrative law or administrative offense or administrative delicts, it depends on the country, being legally defined. So as you already said in your presentation, the term administrative offense is a crucial concept of our administrative penal law or in the field of administrative punishment. But the legal system doesn't provide a statutory definition on administrative offense. Although the Administrative Justice Procedural Code introduced the legislative shorthand administrative offense to refer to infractions, disciplinary or other administrative offenses. However, it doesn't further define these categories. And on the other hand, the Administrative Code is a regulation which regulating the activities of administrative courts. Like, for example, in reviewing decisions of public administration bodies in the field of also in the field of administrative punishment. So it's kind of weird that we have a definition of administrative offense in regulation which regulating the activities of administrative courts, but we don't have a legislative regulation of administrative offense and definition in the regulation which regulating the activities of administrative bodies. It's kind of weird for me. And as you said, we only the legal theory definite the administrative offenses like unlawful conduct, the elements of which are established by law and for which a public authority imposed a sanction prescribed by administrative law, and only the law theory categorizes administrative offenses as infractions, other administrative offenses committed by natural persons, administrative offenses committed by legal entities and self-employed natural persons, and disciplinary and procedural administrative offenses. And only infractions have their own legal definitions, and that is in the Act on Infractions. And second question about the about the fault. So it depends on the type of administrative offense. In the case of infractions, as Monica has already said, only infraction has a legal definition in Act on Infraction, and they said that an infraction is a culpable act and so on and so on. So yes, only in case on infractions, the fault is required, but in the case of another administrative offenses, such as administrative offenses committed by legal entities or self-employed persons or administrative offenses, the fault is not required. They just so-called objective liability, and it is criticized in Slovak Republic, actually, because it is very strict. Then the sanctions, they are really high, and it is criticized. So yes, that's in Slovak Republic. Thank you.
So I kind of feel like the question's been already answered, so I will take it rather brief. So the first question was if we have the concept of violation of administrative law, administrative offense, administrative delict. So it was, as it was already said, we had a big change in 2017. So now there has been a significant legal change in terminology for these concepts in Czech legal system. So we completely abandoned the traditional categorization of so-called administrative offenses and unified all harmful illegal acts that are not criminal offenses under the term offense. As it was said, we have a definition what has to be fulfilled in order to be an offense. What wasn't said was that the Czech law applies a material form concept of the offense. So that means in order an offense to exist, two requirements must be met. First, it's the formal elements such as objective aspect, subject, and subjective aspect. But the second one is a material element, and that can be translated as a social harmfulness. So the act must be threatened or harm interests protected by law. The act must have a certain minimum degree of social harmfulness. Otherwise, it may be considered a minor offense and not be prosecuted. And with the obligation to prove guilt, it's very interesting for me to hear that it's not in all the countries. So connected to the natural persons, proceedings concerning administrative offenses are firmly based on the concept of proving the guilt, and the administrative authority has the obligation to prove the guilt. So they may decide on the guilt and administrative punishment only if it has been proven that the act took place, that the accused committed it, and that all the elements on the specific offense have been fulfilled. So not only formal elements, but also the material elements. And when there is doubts about the guilt, the rule of in dubio pro reo applies. Thank you.
As Professor Król emphasized the misdemeanor procedure, I would like to put the focus on the general rules of environmental protection. And the General Code, it's also was mentioned, defines three forms of liability: the criminal, the civil, and administrative. And I have to add that the General Code of Environmental Protection defines generally what is the negative impact on the environment, which also constitutes the conduct giving rise to liability, may take the form of endangerment or damage. And I also have to add that the concept of the violation can be found generally in the code, the general code. For example, the definition of environmental pollution or threat to the environment or damage to the environment. And the last point must be added that specialized regulations, except misdemeanor proceedings, because I don't think the misdemeanor procedure is a specialized procedure. I mean specialization in the frame of administrative law. So the specialized administrative regulations of the environmental protection also can contain detailed concepts to these violations. And the fourth questions about, as far as I understand it, about the liability for environmental damage or environmental hazard lies with the owner or possessor, user of the property at the time of the environmental damage or the hazard occurred. As far as I heard my colleagues, I could also impose a question about the fines and sanctions. Why is it so important, and why my professor colleague told that there is a problem in your country about it, but we must take into account, and there must be the focus on when someone violate the administrative law. I mean, violate the environment. It's also a violation of human rights at the same time. Why? Because I hope and I guess that in all fundamental law, each country has this right to life and human dignity, and the root of the environmental protection is the protect of this human right. I have to add it, sorry, because I felt that it can raise this question. May I have one more sentence? Thank you. So it can be concluded about the administrative liability in Hungary that the basis of the liability is regulated by administrative law. And liability arises from the failure to comply with or breach of administrative authorities' decisions, and liability is objective. The legislator regulates only a few exceptions. I wanted to list it, but not now. You can read it out. Thank you so much.
Thank you very much for that introduction. I am so sorry we do not have more time, because I prepared the fifth question, and it was exactly the question about a procedural guarantee in administrative and penal administrative proceeding. Because in Poland, for instance, the legislator have to choose, what kind of responsibility he will write in a legal act. If you cut the tree, if you cut the tree, it can be administrative obligation to pay the penalty, but it can be a misdemeanor at the same time. So it has to choose what kind of responsibility to put in act. Administrative procedure is easier. It's easier. It's it not involve prosecutor and lawyers and so on. It's easier. But at the other hand, it's not, for instance, no presumption of innocence, because guilt, for instance, in Poland, cannot be proven. So I have written several, of course, guarantees in administrative procedure, especially in the new act, new section of administrative code from 2017 in this chapter, administrative penalties. And my colleague have written in their papers several procedural rights of accused client or party of administrative proceeding. So we have prepared it, but unfortunately we have no time. So conclusions. Matus said yesterday at the beginning, I will use the words of Sting. We share the same biology, regardless of ideology. We have the same mountains between Poland, Czechia, Slovakia. You have the same rivers. We are breathing the same air. But legislation is completely different. We have tried to show you advantages and disadvantages of hitchhiking. Yeah, so for and against legislation, but we realize that legislation is really different in our Visegrád group. Thank you very much.